Hello, great to see you guys again. Thank you for joining us on another episode of Forecasting Success. Once again, I am your host, Ryan Brannan, and it's always a pleasure to be able to do these and bring quality content to you. And before we get started, I'd like to thank our title sponsor, ARAWC, for giving me the ability to put these together. I always like bringing on important people in the industry that have specific knowledge about certain things and have been around for a long time and are experts in the field. And sometimes we get a chance to talk about specific things. Like last time, we had Hiawatha Franks from TASB, and we were able to talk about the importance of Kids Chance for Texas. And this time, I have Richard Johnson with me, and we're going to spend a lot of time talking about the Chevron decision. But before that, I want to give Richard an opportunity to introduce himself and get you guys to learn a little bit about him before we get into the decision and the ramifications. Richard, I've already messed up a little bit, and then I called it the Chevron decision, but that happened in the 80s, and it was overturning the Chevron decision. But I'm sure you could tell us all about that. But before we do, why don't you say hi to everybody and introduce yourself?
Sure. Well, thanks for having me, Ryan. So I'm Richard Johnson, and I am an Executive Vice President with PartnerSource. We are a broker consulting firm that specializes in the design, implementation, and ongoing consulting for Texas work injury programs, both on the benefits side and on the liability side. So my background, I got my undergrad at the University of Texas. I got my law degree at SMU School of Law in Dallas. I have been practicing attorney since 1992. Before I came to PartnerSource, I worked with the Federal Trade Commission. So we did a lot of work with administrative law regulations. After that, I worked with TXU, the energy company in the Dallas area, where we would do administrative hearings before the Public Utility Commission. So that's it in a nutshell.
Okay, and I have a little bit of SMU connection too, being from Dallas, and then went to SMU for undergrad. In fact, trying to figure out if I can get back up there for the SMU TCU game in a couple of weeks. So stay tuned on that one. If I can't, I may have to find somebody who can take those tickets.
Well, SMU will give them a run for their money this year.
There you go. Yeah, we'll see. Yeah. We'll see how it goes. But I want to go back to where you first started. It's kind of a segue and a tee up really into the issue that we're here to talk about. You were at the Federal Trade Commission. So that's obviously a federal agency who has rulemaking authority. And what was your role there, and how did that work with the rules?
It was just as a clerk, and then as a junior attorney doing a lot of research work, the kind of the things that associate attorneys do, doing a lot of research. But what I really did mostly was on consumer protection law. So you would have these, what I call scam artists, basically, that they would send these things out and try to convince, elderly people on fixed incomes to send them money, send us money, and then you'll get a big prize and that kind of stuff. And so we were about the civil enforcement side of trying to basically put them out of business. So we would spend a fair amount of time in bankruptcy court. Those guys would, they would go bankrupt or they'd disappear and then reappear. Whereas the Department of Justice was on the criminal enforcement side against those. But yeah, it was very satisfying doing consumer protection.
Okay, and that's great to know. And also, I'm assuming while you were there, this is kind of teeing up a little bit where we're going, but the Chevron doctrine was in place. Mm-hmm. We'll get into what that was and then, kind of where we are now in just a minute. But before we get into Chevron, I want to know how you got from the FTC doing energy work and getting into PartnerSource and getting into our industry space.
So that was the idea at the time, is thought I was going to be, either a government lawyer or an administrative lawyer. And so then moved from there to the private sector and into TXU. And those were cases where they would go before the Public Utility Commission here in Austin to try to change the utility rates. And so that's a good example of what we're going to talk about today, where it would be very similar to a normal legal case, but you would go in front of an administrative law judge or public utility commissioners, and they would hear your arguments about whether they would approve what you wanted to do or reject it, or maybe adjust it.
Okay.
So that's what we were doing there. And then I also did some lobbying work for TXU after that. And so when I was doing the lobbying work, I started doing a lot of work on healthcare reform, because that's when Hillary Care was all going on.
Mm-hmm.
And so as I got more involved in that, I learned more about traditional employment benefits, group health benefits, disability. That led to moving into doing some legal consulting on those traditional benefit plans. And then after doing that for a while, I moved over to another area with Bill Minnick and started working on the Texas Work Injury programs. So.
Okay, and was all of that at PartnerSource, or was
yeah.
So how did you meet Bill initially?
He was just one of the partners at the original PartnerSource. So,
okay.
But he was kind of in a different area, and so I always liked working with Bill, but it was a different subject matter. So it worked out perfect, because the knowledge of the administrative work plus those traditional benefits is very helpful.
Yeah.
In bridging the gap on these programs.
Okay, so what I like about where we're going with this is that Richard has experience working in federal government at the agency level, also has private sector experience working back again with government from the private side, and then ultimately also has the non-subscription background as well with PartnerSource. So when it comes to talking about this discussion, as he just told you, he has the knowledge base and the experience from every single angle of which you could possibly take when looking at what happened at the Supreme Court recently and how it affects everything that we do with business and government going forward at that intersection. So why don't we start with what are we even talking about? What is the Chevron deference?
Okay, so just for to step back for a second, just the idea, of course, is that this is really a separation of powers issue, a power struggle that you know all too well between the legislative branch, which is supposed to write and pass the laws, the executive branch, which should implement those laws, and the judicial branch, which has the job of reviewing those laws to make sure they're constitutional. Uh-huh. So what happened here is that over the course of the last 40 years, you saw an increasing amount of federal power. And really in the last 4 years, you've seen it go to the next level, where you've seen the executive branch at the federal level looking for ways that they can use all the tools in their toolbox, things like executive actions and regulations, to find a way to kind of do an end around on the legislative process. It's their way that they can change the law or advance their policy agendas without having to go through the fight that you have to go through to pass a law.
Right. So you and I know what that means.
Right.
But a lot of people that are watching this don't understand what that means. Is there a way to explain that to, in very simple terms about agency rulemaking and authority versus legislative authority?
Yeah. So again, the legislature will, they're the representatives of the people, and they will get together and someone will introduce a bill. They will, it goes through committees, it gets refined, it gets changed. There's a lot of back and forth. Then if it makes it past the committee, of course, it goes to the full floor. In this case, the House, typically, if they pass it, it now moves over to the Senate. Then they've got to fight about it, and if they pass it, now it goes to the president, and the president still has the ability as the executive to veto that bill. But if he signs it or she signs it, now it becomes a law, a federal law of the land. And
that's been intentionally, through the process of the House committee, House floor, Senate committee, Senate floor. Everybody's taken a look at this. It's been well vetted by the time it gets through.
Right.
Every word in there has been debated and discussed and negotiated.
Exactly.
And so you have more eyes on those pieces of legislation typically than you do in any other way to pass a law,
right?
Particularly when it comes to an agency. And I think what you're saying is, so that you have this track through the legislature that passes a law that's well vetted, and in Texas's sake, there would be 181 eyes on it. You had the 150 House members, 31 senators. Everybody gets a chance to have their say or input or piece of that. and then you have executive branch agencies, and that process is different.
Yes. So the process is really much harder, kind of what you're saying, because one, it's the representatives of the people, and that's the way it's supposed to be. And so it's much harder because there's so many people that have their chance to argue about it and get it through. Whereas at the executive level, they will create what they call regulations or rules. And what that process is that the idea would be is if the law is the bone, then the regulation kind of fills in the detail, puts the meat on the bone. And so the purpose of that is to clarify to me, how do we take this broad law that got passed and provide the detail that we need to, as a business, to apply that law in the real world? Mm-hmm. So what happens at that point is that the agency, there'll be all the different agencies in federal government, and they all have certain responsibilities for areas of our society. And whichever one is in charge of that issue, they will then write what they call a proposed rule, and the proposed rule will suggest, here's how we're going to lay out how to implement this law, and we're going to give you, the public, a chance to comment on it. So they have a public comment period. We go through that process, people make their comments, then they take all those comments, the federal agency, and they make some final tweaks and adjustments based on the feedback, and then they issue a final binding rule. That's a regulation. It's not a law. It doesn't have the strength of a law, but it's just below that in terms of authority.
Right. Well, in Texas, it's in the administrative code, so it's I guess technically law, but you're right, not at the same level as every
it's
other
binding.
code.
It is binding. It's binding.
So, for example, when we were at the agency, when I was commissioner of the division, which is Texas, not federal, but it's a similar concept. When I was there, we would frequently get bills passed from the legislature that said, this is what we're trying to do. We want to make sure A, B, C, and D are in there. And then we direct the agency to write rules. So there are times when the agency is directed by the legislature to write rules with guardrails and specific things in place. And then there are times where the agency just decides unilaterally that they want to create a rule. And that can create its own set of issues as well. So given the two different tracks of how binding authority, whether or not it be statute or administrative code rule, gets put in place, and we know that the legislature is vetted through a whole process. We know the agency is really up to the commissioner or commissioners of that agency.
Correct.
And yes, like you said, there's public input. You put out a draft rule, you receive stakeholder feedback, typically you have a hearing. But at the end of the day, it's that agency head or heads who sign it based on what they think. So you don't have all of that vetting process. You have 1, 3, 5, or 7 people deciding, depending on how the agency is structured.
Right.
And so let's go back to the Chevron deference coming into place.
Okay.
What did that say about these two tracks, and what was the impetus for that and how it got put in place?
Yeah. Well, so kind of back to the, where the conflict has started to happen more now is that you've seen these areas where the federal government, the executive branch, has tried to use that rulemaking regulation process to kind of, again, circumvent what the law says. Mm-hmm. A good example that everybody hears about right now is the student loan forgiveness issues, right?
Okay. Perfect.
They just said by fiat, we're going to forgive all these loans. We don't really care what the legislature, which is made up of the people, says. This is the deal. And that eventually got struck down by the court. Another one with my old agency, the Federal Trade Commission, is they recently tried to ban non-compete agreements in employment contracts. That's a big deal, and the kind of thing that should really be debated and fought, like you said, through the congressional process. They didn't do that. That's now been struck down, at least in Texas. Mm. So those are two examples. So to your back to the Chevron issue.
And to your point, I'm glad you brought up non-competes, because this is very timely in that on Tuesday, the lieutenant governor here just put out a new set of interim charges, which I don't think has ever been done, at least not since I've been around, where you have 2 sets of interim charges, let alone a set of interim charges come out in September right before we go into a legislative hearing. So the agencies have almost little to no time to work on these.
Right.
And one of them is on non-competes. And what's happened as a result of the Supreme Court decision is going to be a big part of the reason why we're here now in Texas. But extremely relevant, timely topic. So thank you for bringing up that example.
Oh, yeah. So now what happened is that if you wanted, so what the Chevron doctrine is there was a case in 1984 called Chevron versus EPA. And what happened in that case was that the Supreme Court, the U.S. Supreme Court in D.C., established a standard that says that when federal courts are reviewing the regulations that have been enacted by a federal agency, whichever one it is, they have to give deference to the interpretation that the agency gave when they wrote the regulations. So in other words, what I say, they have to give them the benefit of the doubt.
Right.
So what that does in practical terms is that if you're an opponent and you're challenging to try to block that rule or get rid of it, a judge might say, you know, challenger, I agree with your opinion, but at the end of the day, because the interpretation by the agency was reasonable, I may not agree with it, but because it was reasonable and because the law is kind of vague on that topic, I'm going to let it pass. I got to give them a pass. And so they win. So that was the standard for 40 years.
Right. Essentially, courts deferring to these agencies and the rules that they made when they were interpreting law. And, you know, in theory, everybody's a good actor and they're trying to interpret what the law said. But, you know, in practicality, that's not necessarily always the case. That they put their own spin on it.
Exactly. Gave them a lot of power.
And so for 40 years in the United States, the courts just said, okay, well, you could do that, which gave a lot of power to federal agencies and removed a lot of power from the legislature. So we discussed how the Chevron doctrine has been in place for 40 years, giving agency heads a lot of authority over how to interpret the law. But recently there was the Loper decision and several others. Can you walk through those cases a little bit about kind of what those cases mean and what they mean for us going forward?
So all four of them were decided at the same time, and Loper's the biggest one because it flipped that standard of now we get to, judges have a lot more power to interpret these regulations. But the other ones, there was one that was an SEC case, and what they said in that one is they limited the ability of the penalties or damages that an administrative law judge can impose. So they said, you know, normally like I talked about with TXU is you go before them and they either approve what you want or they deny what you want. Well, in that SEC case, they went beyond that and they were actually assessing damages against the opposing side. And so the Supreme Court just said, no, you can't do that. That has to be in a court of law. That's a legal remedy, not an administrative remedy. So the reason I bring that up is that really hamstrings the enforceability that these agencies now have to go out and enforce their law. Yeah. It takes some teeth out of the tiger. Another one was Ohio versus EPA. And what that one did, we talked earlier about the fact that when an agency issues a proposed rule, there's a public comment period and everybody gets a chance to get their 2 cents in. Right. Well, in this EPA situation, they totally ignored, blatantly ignored all the comments. And they just basically finalized the rule exactly like the proposed rule. And the court in that case said that you can't do that. You have to at least acknowledge those comments in the commentary. And if you didn't accept those comments, you have to explain why, right? You can't just blow it off.
That's common sense. That goes back to my point earlier about, you know, in theory, everybody's acting in good faith, right? I mean, I remember, you know, at the Division of Workers' Comp, we had the fentanyl problem.
Yes.
We were trying to figure out how best to solve it. We had ideas internally. We put those together into a rule, and then we went out to stakeholders for feedback. And they're like, oh, you can do this, no problem. You can't do this. This would mess us up here, there, and the other thing. And you take all that and combine it and in good faith, try to make a rule to help curb the fentanyl problem among workers. Right. You know, and a large part of that was compound pharmacy. They were having fentanyl lollipops. These workers were just sucking on fentanyl lollipops all day.
Unbelievable.
So that's an example of where you're actually trying to solve the problem and listen to the stakeholders that would be affected by this rule and you know how best to craft it. But to your point, and you know, not everybody is necessarily acting in good faith in the system. And so, you know, you have an agency like the EPA that thinks that because of 40 years, why wouldn't they think any different?
Right.
Could do whatever they want to do.
Exactly.
And then just get so egregious about it that the final rule is the exact same as the draft rule, and they don't even acknowledge any of the comments in the public
Which
comment.
is really egregious. After, working with regulations for as long as I have, there's always a section at the end that talks about, gives hypotheticals like, okay, well, here's an example of how this would apply in the real world, or in response to somebody's question, or here is, the way that we heard your comment, but we don't agree, and this is why. Yeah. That's always in there, but they just ignored it. The last case was this corner post against the Federal Reserve System. And what that one did is a big deal for all agency challenges, because they said normally it's a 6-year statute of limitations, which is, of course, the time that if you want to challenge that regulation, you've got 6 years from when they make it a final rule to challenge it. What this case said is that the clock doesn't start on that statute of limitations until the party is injured. Not when the law is passed.
Okay.
That's huge,
Yeah,
obviously.
absolutely.
Because now, we had a Department of Labor investigation, of course, for 5 years that argued about whether a 24-hour injury reporting requirement was reasonable. The regulation that it applied to, the ERISA regulation, just says that the claims rules have to be reasonable. That's it. So we got in this big argument about 24 hours. Well, now those parties could argue that we weren't injured until the agency ruled against us and made us change our plans, and they didn't impose penalties, but let's say they did.
Right.
Now the clock would start and they could challenge it, and not only do they have a later ability to challenge it, but as we talked about a minute ago, it's game on. It's a fair fight, and they have the ability to make their pitch to a judge, and the judge can decide that they're right.
Yeah.
Big difference.
So all 4 of those cases combined is really a paradigm shift.
Yes.
In soccer, if a goalie's playing real well, you say they're standing on their head. But this is essentially standing on the head, the whole apparatus of the federal government.
Right.
And so, what do you think that means going forward in general? And then I'll come back and I'll ask you again for non-subscription for our industry. But as far as businesses operating and doing business, and legislation and rulemaking, just from a big picture standpoint, what do you think this paradigm shift means for how the whole system operates?
Well, and that's going to be a good question, but I think that the pros and cons, I think on the pro side, again, I think it'll be much harder for agencies to write these rules. They're going to have to be much more narrow, and they're going to have to be very clear that they're tying it to the terms of the law. They can't just stick stuff in there that's nowhere found in the law that they're trying to regulate. So that's number one. I think, again, it's a much better process for challengers to attack that rule because they know that they've got time to do it and they can have a fairer fight. So, for example, back to the Department of Labor investigation issue.
Well, before we get back there, I was going to jump there, but no, I just wanted to add real quick. It's funny that you say that the agencies are going to have to be really clear with their rulemaking. I don't know if it's because I'm a former commissioner, but I thought, to me, it means that the legislators are going to actually have to work. They can't just punt everything to the agencies, right? Because that was one thing that they used to do is agency write rules because we don't want to get into the minutia.
You're right.
Well, we just want to be able to say that we solved this problem and now here it's your fault. But now they can't do that, or at least it's going to be a lot harder for them to do it. And so, where they would punt to the agencies for rulemakings to get consensus to get something through, they're actually going to have to negotiate those important details.
Yeah.
And I think that's great for the process, for people's representation. So that's just my own personal take on it that I wanted to add in there.
No, I agree.
Into things that I think will have to happen going forward as a result of this. But yeah, you mentioned the Department of Labor investigation, and so yeah, that's a great segue back into using that as an example of what could happen going forward. Yeah.
I think another thing back to the big picture is that I think it's going to definitely delay the process. So if you're a business and you're like, I want as little regulation that I have to deal with as possible, especially small business, this is a great news because now it's not just that final rule and here we go. the odds are very good that there's going to be a legal challenge, and that's going to just push the whole process back that much farther.
Right.
So that's, I think, overall good news.
Yeah.
And then we talked about earlier their ability to enforce those rules. There's a lot less pressure, I think, if an employer doesn't want to necessarily follow it. So again, back to the Department of Labor example.
Mm-hmm.
So when the opponents, the 4 employers that were being investigated and the industry groups that were also helping them, gave the Department of Labor examples of other areas that said that 24-hour injury reporting is reasonable. They showed there's a Texas Supreme Court case that says 24 hours is reasonable. They also had a OSHA. They looked at OSHA regulations.
Mm-hmm.
OSHA says that you can have a reporting time frame as short as 8 hours for reporting an accident. So they're like, clearly, everybody else says that this is not outrageous. But that's a good example of, in that scenario, the Department of Labor is like, that doesn't matter.
Yeah.
At the end of the day, we want it to be 30 days. We think that 24 hours is not reasonable, period.
Right. And I remember being on multiple calls with the White House, with the Department of Labor, with several federal legislators, and they just wouldn't move off it. They were on a witch hunt. And that's the only way I could describe it, as a witch hunt.
Yeah.
But it didn't make any sense, and yet that's what they were, a dog with a bone, and that was their bone, and you couldn't shake them. And so 5 years of that, but now the game's changed, right? They don't get to just decide that we don't like 24 hours, and that's just the final say, right? I mean,
well, and that's right. I mean, now it's like they're just like right now we may have non-binding guidance that doesn't officially apply, is not a rule of law, but we can't ignore it. We know the politics of it says that tells us how the Department of Labor thinks, and we better pay attention to what they're saying, because if they come and audit us, we need to be ready. Well, now that flips on the other side to say, well, okay, Department of Labor, you can still do what you're going to do, but now you've got to worry about, we can come back to a judge, and the judge may disagree with you about those standards and say, yeah, it looks like it's pretty reasonable to me.
Yeah. So how do you think that's, so this is a very important example. It's not just an example we pulled out. I mean, this is real world.
Yep.
And to your point, I mean, it changes the leverage of the conversation entirely.
Exactly.
Which is the way you want it, right? I mean, it should be, I mean, just to say it, I mean, this is still America, right? We want people to have businesses. We want people to be able to go to work. We want people to live the American dream. And if you are doing things in a way that is beneficial to your company, beneficial to the workers, beneficial to the ecosphere, who in the world is the government to get in the way of that just because they don't like a specific provision in there? I mean, it's backwards, and we finally fixed that.
I think so.
Or I hope so. I mean, if not, well, I mean, we'll find out as this shakes out, but it certainly seems like we did.
Yeah. I think some of the cons that we might see from it, everything's a double-edged sword. Beware of what you wish for.
Right.
But one of the cons a couple of the cons I could see is that because you may start now seeing more what I call non-binding guidance that federal agencies provide to help people understand what the law is and how to apply that law to their business. And the downside of that is they can just issue an opinion letter, or they can issue a bulletin, and they don't have to get any public comments at all. And again, so it's just all their publications, and that doesn't have any weight to any binding. We're not required, but it kind of puts us in the same quandary like this Department of Labor. They issued a report, and that report only affected those 4 employers. But in the real world, we all read it and said, this is what they're thinking. So we struggled with our clients talking to them about, should we change that reporting rule? About half of them did, about half of them didn't. So I think that's not going to solve the problem. We're still going to have some kind of ambiguity. I think the upside is I think employers could maybe be a little more emboldened to say, we're not going to follow it, these little bulletins and guidance, than maybe if it was a regulation where it's like, you have to follow it. But it's still going to create some confusion and less ability to give proactive guidance before you're in a courtroom, if that makes sense. So I think that's
absolutely.
bad.
Yeah. And again, and I mentioned this earlier, but it's the intersection of law and politics.
Right.
And you had a federal administration that Texas did not vote for as a whole and did not like Texas. And whereas in Texas, Governor Perry and now Governor Abbott tout our system when they recruit other businesses to Texas.
That's right.
In fact, I think it was my second week, maybe third week on the job working for Rick Perry, however many years ago now. I had hair then, so that should give you some perspective on how long ago it was. But they asked me, they said we need bullet points on the Texas workers' comp system, particularly you have options and different employers take advantage of it. And I still knew enough. I was just like, okay, I'll put them all together. And then I said, why? And they said, well, because Governor Perry's about to go to California on a recruiting trip and wants to use these as an example of a reason why those companies need to move to Texas, right? So all of that is free market good stuff, right? Companies decide what state and what regulations they want. Then you have a state that's working, that's literally bringing in jobs. I mean, Texas, Abbott has all the trophies behind his desk. We've won the Governor's Cup, 14 plus years in a row of creating the most jobs. It's insane. And this is a part of that. And so you have an administration who sees that success, doesn't like it, politically go after it. And and that's what's been happening, at least from my perspective as the former commissioner. And just having a background in politics. And it's not an R or a D thing. It's a our team versus your team thing. And our team, Texas has always been open for business, right? That was Rick Perry's slogan for a decade.
Exactly.
And so now, you're taking away one of the hammers, at least, out of the toolbox of the federal government to be able to just open up an investigation. And now all of a sudden, there's a cloud of controversy and a swarm of concern. Because quite frankly, I think these, in my opinion, these decisions opened up the fact that these agencies aren't necessarily just good faith actors, that they are political entities working in their best interests and the best interest of that administration. And so for businesses to be at the whim of political administrations is problematic
on either side.
Yeah, on either side.
On either side.
100% on either side. And so I think this turns it around. They have to start justifying themselves.
Exactly.
And you can have those conversations now, and you can have them out in the open, and you can have them through litigation. You can have them through public discourse. But it opens up. It's more transparent now, and they have to validate why it is that they're doing what they're doing. And I think reasonable minds can make up their mind on whether or not that's valid or not. So from my perspective anyway, as a former regulator and as somebody who deals with politics on a daily basis, it's a game changer for business.
It is.
And I'm just excited to see where this goes. And particularly with NotSub and with where we are and what we've been doing, I mean, this could have significant ramifications.
Yeah. I mean, the upside of what made me love doing and still love doing Texas non-subscription, the upside and the challenge of it is that it's the Wild West. It's this, we've always kind of flown under the radar to a certain extent from federal law, and the arguments have always been at the state level, trying to preserve it at the state level, possibly expanding it to other states. Well, I always knew from my background in the federal side that, the day is going to come when the federal government finally gets involved or flips under a rock and says, what's this stuff? And then all of a sudden starts, possibly attacking it. And that's what happened in 2015. Yeah. And to our credit as an industry, we fought hard and we succeeded. But I think that's always been a challenge. Early on, back in 2005, when it was dealing with HIPAA privacy rules, for example, or the Affordable Care Act, the challenge is always, how do these federal laws that have no concept of what a Texas work injury benefit plan is, how do we apply those things or not apply those things to these cases, knowing that we don't have any guidance and we're just hoping for the best?
Yeah.
So the DOL investigation about the 24-hour rule was really, there were many things that we'd ask for proactively for guidance. Tell us, we want to follow the law, and never would get any responses. Pretty much for almost everything, until the first time we were getting a policy discussion, we were in the middle of 4 employers in the middle of an investigation.
Yeah.
There's a better way to do it.
Right.
More collaborative way to do it.
Correct. So do you think as a result of these cases, we'll get to that better way, that more collaborative
I hope
way?
so. I do. I think that my fear is that they'll just punt. They're writing and defending these regulations is more trouble than it's worth. On the upside, that's great because it frees up business for sure. The downside could be, though, is that they're just giving us very generic information that's really not helping us doing the job that they're intended to do, which is to help guide us to transition us from that statute to following it every day in our business.
Right.
If that makes sense.
Yeah, it makes a lot of sense. So do you think there'll be any other kind of fallout peripherally from just the rulemaking and the investigation aspects of it? Like, do you think as far as how business and government interacts that there will be other areas that could be affected or as a result?
And what's now specifically for Texas work injury programs, there is a case that's right now in the Fifth Circuit.
Okay.
And so that case is Utah v. Walsh. And
okay.
what was going on in that case is it dealt with a retirement plan. And so ERISA, these are ERISA regulations, which is ERISA is the federal law, of course, that applies to Texas work injury plans. And so what happened there is they had a regulation that said if you're a retirement plan manager and you're trying to decide between two different investments to invest, and some of these are millions and millions of dollars that they're investing, you don't have to, but you kind of should look at the ESG, which is, the environmental, social, and governance rules. Are they in climate change? Are they in this and that and diversity and all these different things? And you should look at that to figure out, which one to pick. Well, the opponents, including the state of Texas, the Attorney General for Texas, joined several states to fight that, and the district court followed the Chevron rule, which was in place at the time, and said, hey, I have to follow that. I have to give them deference. Well, now it's in the Fifth Circuit. Loper has come down, this new case, and they just had oral argument like literally the other day. And so I think what's going to happen, I'm guessing, is that they will probably remand it. They'll punt it back to the district court and say, okay, district court, you need to reevaluate this case based on the new rule, Loper, and see what you think. And then if they, I'm going to make you do the hard work. And then it'll probably get appealed back to the Fifth Circuit, but it's going to force that district court to determine, is this a legal rule or not? Because the opponents were saying there's no ESG rules in ERISA. ERISA was in 1974. They hadn't even dreamed about what that was. So they've got a good argument.
Yeah, it'll be interesting to watch.
Yeah.
So are there any other cases or any other things out there that you see that could be affected and could affect this industry? Not to put you on the spot.
No, not specifically on that, but I think that there was another law that Congress tried to pass in 2022, and it was the Employee and Retiree Access to Justice Act. And what that sought to do was two things. Number one, to really limit, if not eliminate, the ability of employers to arbitrate ERISA claims, in particular ERISA breach of fiduciary duty claims. So the idea is that, I have a duty to administer benefit claims in the best interest of the employees, the injured workers, and I've got to do it consistently. I talk to clients about that all the time. You got to treat the guy on the dock the same as the CEO. But the law changed on arbitration and made it more open, at least nationally, to where a lot of people said, historically, we have not led those cases into arbitration, but this changes in the law made employers a lot more aggressive about putting arbitration for these ERISA claims. Well, this law tried to basically outlaw that, number one. And number two, it's a reverse of the Loper case. Just not to get too deep in the woods, but this now goes to the challenge of private business versus government as a whole. So there's a case called Firestone that's been around since 1989, and it's in everybody's, at least our clients, every Texas work injury benefit plan, where we write in a standard based on that case that says that you can't just second guess what a plan administrator's decision is on whether to approve or deny a benefit claim. You have to give them deference, right? It's the opposite of what we just talked about.
Right.
So this law tried to change that and say, now we would let courts second guess the decisions of those private business administrators. And what that would do is create a whole lot more ERISA lawsuits because, right, plaintiff lawyers, in addition to bringing a liability claim, would say, well, I'm just going to throw a ERISA claim in there too and see what happens. So the good news is that one passed the House in 2022, but it got killed in the Senate. Yeah. It has not been reintroduced, but it's something that we're keeping our eye on.
Well, why do you think that? Why do you think it passed the House, not the Senate?
Just back then, it was a Democratic-controlled House, and now, so that's why elections matter.
Again, back to the politics,
right?
With
intersection
with politics.
It was just the politics.
That's the way it goes. So what else do we need to know about Chevron being overturned, essentially? The Loper case, the other cases associated with it, and what that means. So for those that are watching that, aren't in the legal or political world, but are working on claims management or doing what the different aspects associated with this whole ecosphere.
Yeah.
That may not necessarily be watching this or paying attention to this. What do they need to know going forward? What do we think the impacts would be? What else do you want to tell folks while you're here?
I think overall it's a very, very positive impact because the whole, as you know, the concept of a work injury program is freedom, and Texas is all about freedom. Our freedom to, do things as we see fit if we do them professionally and reliably. So this continues to enforce that theme of government. You need to stay out of our business to a certain extent, and not abuse your authority, and gives a lot of that authority back to courts, who at least have to give us a fair fight, a fair shake, and also to the extent gives more authority back to the people who run the plans, who run your business every day, and are just trying to make Texas a great place to be.
Yeah, perfect. Well, Richard, I appreciate you coming on.
Thanks for having me.
Thank you so much.
I appreciate it.
Everybody watching, Richard Johnson, it was a pleasure to have him with us. And I think the main takeaway is that freedom wins the day in Texas as a result of the Loper and other decisions. And we'll keep an eye out and monitor going forward and see what other fallout happens from those decisions. But very good for our ability to continue to operate and operate effectively in the state of Texas. And thanks for joining in. And until next time, Ryan Brannan with Forecasting Success. Thanks again to ARAWC. Always a pleasure to be here with you.